You can be seated.
Mr. Way, please have a seat. Mr. Way, stand up. I'm sorry. Please step up to the podium, Mr. Way. I apologize.
Good afternoon.
Good afternoon.
May I please the court? My name is Hung-Chieh, and I represent my client, Mr. Brown. Here is I prefer the illegal seized property is not admissible in the court because the police violated my defendant's, my client's Fourth Amendment rights.
And how did they do that?
They don't have the reasonable suspicion to stop and seize the property.
What case do you think helps you the most?
My case is according to the Florida versus JL.
Why do you think that case helps you?
Because first is this Supreme Court stressed how important the fundamental right is, and say the anonymous tips is not enough to create a reasonable suspicion.
Anonymous tips, the words of the court are anonymous tip without more. Don't we have more here? Don't we have, for instance, didn't your client run when he saw the police? And he ran for several blocks holding something in his pants, and he disobeyed their order to stop. Isn't that more than just an anonymous tip?
Yeah, here I want to compare to the Wallow case, because the Wallow case focused on the totality of circumstance. And my
Well, that's
case,
the law, isn't it? Don't we have to look at the totality?
yes, we have to. In our case, like in Wallow case, it's an unprovoked flight with a high area, high crime area, and a lot of things. But in our case, the very different is my client just obey what police order him to do, is to disperse.
Go ahead.
And because that disperse you can do in any way, he's choose the way to run. So in my opinion, this a totally different case. So it's distinguishable.
Well, your client was with a group of other men. He was the only one who ran, wasn't he?
Yes.
And he was the only one who was holding something in his pants, as far as we know, wasn't he?
Yes.
And he was the only one who refused to obey the order of the police to stop, wasn't he?
I respectfully disagree, My Honor.
Go ahead.
Here is the, in that, according to record, I refer that my client is freak out to death. Yeah, because he is the only one. There is not unlawful conduct in front of the bar.
Well, if the police are saying throughout the chase, shout, halt, police, what about that would make you scared? Wouldn't you stop? What should the police have done? Just said, oh, sorry, wrong guy, and moved on?
Yes, Your Honor, I got this point, but I will say because the police, when he shouts, my client, when he's in that neighborhood, he grew up from that neighborhood, probably everybody have freaked out to being chasing.
That's not in the facts. That's not
Right.
part of the facts that were found. So that's not a basis for us to decide the case.
Right.
You have to stick to what's here.
Why don't
Okay.
you conclude your argument, Mr. Way?
Okay. There's a saying by Benjamin Franklin, they who give up their essential liberty to purchase temporary and little safety deserve neither liberty nor safety. This is just our case. Because my client, the police don't have the reasonable suspicion to justify his conduct. So here is I ask my court to grant the motion to separate the evidence. And it's the only way to protect the Constitution we obey and we believe for over 200 years.
Thank you very much.
Mr. Smacchi?
Good afternoon, honorable judges. May I please the court? My name is Matteo Smacchi, prosecutor for the United States District Court of the Eastern District of Pennsylvania. The question presented here is, under the totality of the circumstances, do the police officer have the reasonable suspicion to stop and frisk someone that standing alone in a high crime area, where the police received numerous complaints in that area about gun and drug crimes, and ignore the police order and flee unprovoked, holding something in his waistband? And we know that police also give enough time to disperse.
Well, what about the idea that you have a house built on a rotten foundation? You've got police action triggered by anonymous tips, just like in Wardlow. You have we don't know who the neighbors are. They're anonymous complaints, just like in Wardlow. And everything flows from that. And therefore, we have to suppress, just as the Supreme Court suppressed in Wardlow.
Wardlow represents my leading case because there are...
I'm sorry.
JL.
I said Wardlow, but I meant JL. just as in JL.
In JL, we have elements that are not present in the Thomas Brown. First of all, we don't have an anonymous tip here.
Well, do you know who the neighbors were who complained?
We know that there are numerous complaints about gun and crimes
We
based
don't know
on...
who made them, correct? We don't have people's names, do we?
we don't have...
Then they're anonymous, correct?
That's
Just
correct.
like in JL, correct?
That's correct.
Then why don't we suppress just like in JL?
Because here, according to Wardlow, the Terry versus Ohio typical stop is fully warranted when we have the element of high crime area and the unprovoked flight. So these two elements, there are exactly the same element in Wardlow versus Illinois and in the Thomas Brown case, allow police officer to make a further investigatory stop. And this is exactly what the police officer did. They stopped to make further investigation. So under the totality
your
of...
opponent suggests, I didn't mean to interrupt you, sorry, that it wasn't an unprovoked flight. It was provoked. The police told him to run. The police told him to leave. So he was like, yes, sir, I'll leave. And I'll leave very quickly.
But it's interesting, first of all, that according to what the judge has said before, he was the only one that ran. And second of all, they first of all asked the group to disperse. And after 10 minutes, the group didn't disperse. So it's interesting that the group didn't disperse immediately after the police order. And we know that also under the code of conduct of any police officers in Pennsylvania, they are allowed to ask to a group of 4 or 5 males to disperse.
Well, that's not in the record,
It's true.
so we can't consider that.
Of course. So we know that the circumstances present in this case, so the high crime area, the number of complaints in particular in front of the North Bar, and the number of complaints that they receive, high crime area, and the flight, this kind of flight, are enough, represent the circumstances that are enough to stop and frisk someone. And we know also that after they stop and lawfully frisk him, they lawfully seize the gun. So the totality of the circumstances here can show us that was absolutely lawful, all the behavior from the police officer. And I want to also add that they show immediately who they were, because they have a marked police vehicle. They immediately said all police after he started to run, but he submitted his, after they showed the authority, he submitted himself to the authority, and he said, okay, you got me, after they showed. So also, if you don't want to use just Wardlow versus Illinois, we can also use Odari.
We understand. Why don't you conclude your argument?
Yes, for all the foregoing reason, respondent United States of America, by and through his counsel, prosecutor Matteo Smacchi, respectfully request that this court deny the motion to suppress of petitioner Thomas Brown because police officer lawfully seized the gun, so the gun should be admitted as evidence.
Thank you both very, very much. You both made very, very fine arguments. You both strayed a little outside the record. You talked about the neighborhood where he grew up. Those aren't facts found by Judge Rice. You really can't consider it. You talked about police codes of conduct, which aren't before us, so we can't consider that. So you got to be careful, both of you, to stick to your record. You correctly recognize that JL is your best case. It's your only case. It's all you have. And you made the best use of it you could. I loved your Ben Franklin quote. Mr. Smacchi, I thought that your beginning of your argument was terrific. You said under the totality of the circumstances, they had reasonable suspicion. I think you could say even a little more than that in your brief, just as you can begin the argument section of your brief with JL, you could begin the argument section of your brief to say Wardlow controls here. under the totality of the circumstances test that's set out in Wardlow, this court is compelled to deny. And you can say, under the Supreme Court's holding in JL, this court must suppress because this seizure was based ultimately on an anonymous tip. I thought you both did a terrific job, and you both dressed for court, which we appreciate very much. Thank you.
One point for each of you. You did something that I don't even know you realize you did, but it was very, very insightful. You took the totality of the circumstances test, which helps Matteo, and you used it to your advantage by saying, if we're going to look at totality of the circumstances, Judge, we have to look at why my client ran. And he ran because he thought the police wanted him to disperse. And I think if you weave that into your brief like that, that's very, very insightful. Matteo, two things. You got more than somebody just running in a high crime area. You got somebody holding their waistband, which suggested to police what?
That he had a gun.
Gun.
They have something.
And you have, what time is it?
It's
It's
not
dark.
It's dark. So if
Courts
the police,
always defer to dark.
if the police look over in the dark and they see somebody fiddling around with their waistband, if that's not reasonable suspicion, I don't know what is. So, I mean, I think you can tighten your brief up by emphasizing.
Thank you both very, very much.
Thank you.
Thank you all very, very
Could I
much.
thank the honorable judges, Bryce and Diamond, very much for today.
Oh,
Are you willing to take a couple of pictures?
sure.